You have the right to remain silent.
But we'd prefer if you didn't.
Spinning the law, spinning the law.
This is Malzberg's
Spinning the law,
Spinning the Law
spinning the law, spinning the law.
with attorney Kendall Coffey.
All right, folks, we welcome you back to the Big Steve Malzberg Show, and we say hello to the one and only Kendall Coffey. Hello, sir.
Hey, Steve. How are you? Happy Friday.
Happy Friday. It is Friday, and it's beautiful out here. I assume wherever you are, it's pretty nice out?
Spectacular. Looking at some Atlantic Ocean and some sailboats right now.
Nice. Very nice. Well, I appreciate you including me in that that whole, puzzle or whatever it is, painting. Anyway, okay, let's talk a little bit about, of course, the Supreme Court decision that came down earlier this week, knocking down or basically what it did was it upheld the right of the people of Michigan to decide to knock down racial quotas as a tool for admissions into their universities.
And there was a very energetic, perhaps passionate dissent by Justice Sotomayor. It was a 6-2 decision. Justice Kagan did not appear. But what was interesting is you didn't have just 5 Supreme Court justices in favor of the result. You had Justice Breyer,
yeah,
who
6.
we call was an appointee of President Clinton. And the message really was that states can make some choices in this area. That it's certainly not an easy, subject for anybody, but that, as I think Justice Kennedy put it well, the issue really wasn't do you have, is it a good thing, is it a bad thing to ban any consideration of race as was done by the state of Michigan with respect to university admissions, but isn't that something that could be within the prerogative of the state? So, for example, if a state wants to have some consideration of race, not as a quota, but as a plus factor, should the state have the right to do that? And if a state wants to completely eliminate any use of racial preferences in university admissions, shouldn't that be within the prerogative of the state? So, kind of the bottom line was that it really is seen by Justice Kennedy and the majority of the court. It's not about racial preferences, but how that issue should be resolved. And again, the decision that the court made is it should be decided by the people of the state. We emphasize this isn't a case where there was evidence of past discrimination and that this might affect a remedy. This was a situation where this is what the state of Michigan decided. It was upheld. It's an important decision, Steve. I think other states may consider following it. But in some ways, it's a landmark. In some ways, it's expected.
Well, let me ask you this: why does it then not extend to, and maybe I'm jumping to a conclusion, but this is from everything I've heard and read. Why does it then not extend to, let's say, the right of a state to have a Prop 8 in California? I know it's a different issue, but is it not the same state's right kind of an issue where the people have decided this is how they voted and they have a right to? Or how is Prop 8 different than this prop that was voted on by the people of Michigan?
Well, I mean, that's a fair question. As we know, Justice Kennedy, often the swing vote, had written an opinion that struck down something somewhat similar in Colorado in the sense that it affecting gay rights laws. Mm-hmm. I think that the Supreme Court has simply reached a point with respect to our history where some of them think, and Roberts, Chief Justice Roberts, has a very quotable comment as well, that we've reached a point where forms of quotas with respect to racial and other minorities, ethnic minorities, are simply not something that is required. It's almost a policy decision. It's a view of history. It's not necessarily strictly speaking a view of the Constitution. You recall that Justice O'Connor had said that there should be some form, in her view, of a plus factor for at least another couple of decades. Right. This court seems to be reaching the conclusion a little faster in terms of watching the flow of history.
So was
that,
this? I'm sorry to interrupt. I'm sorry to
No,
interrupt.
no,
So was this a decision based on the court's view of affirmative action, or was this a decision based on that said they had the state of Michigan had a right to vote on this, and they voted on it legitimately, and it'll stand because they have a right to decide these kinds of things? And do they and obviously they distinction and make between racial quotas and gay marriage. I mean, no?
There seems to be such a distinction. I think this would be, as the Supreme Court described it, a decision that's based on the prerogative of the people of the state to make that kind of decision in this very difficult area. But I also think that it's consistent with a judicial momentum, and I would not be astonished at all to see a further approaches with respect to the subject of affirmative action over the next 5 years. I think that at some point it's going to be reconsidered again, and I'm not sure that any form of racial preference is going to survive the next treatment.
And I hope not, but let's keep in mind that, God forbid, in my view, President Obama gets to replace the swing vote and maybe a conservative justice between now and the end of 3 years, and then all bets would be off, I think.
Well, I think the 2016 election is going to kind of decide that. I'm not sure anyone's expecting any retirements between now and then.
No, not expected, but the unexpected.
The 2016 election is going to define the future equation of the court.
Yeah, very, very important. All right, let's talk about this. The Supreme Court refused to intervene in the execution that took place in Missouri. A convicted killer. After the governor denied the request for clemency, and they executed William Rousen, 57 years old, and his lawyers argued that the secrecy surrounding the lethal injection drugs could result in undue suffering for the inmate as he was put to death. Now, this isn't the first time, I don't believe, that this issue has been raised, and I know the left went crazy on it at some point, saying it's inhumane, blah, blah, blah. Not this particular case necessarily, but is this a precedent setter now? I mean, is this issue kind of like behind us now because the lawyers wanted to know exactly what the drugs were, and because they couldn't find out, they feared it might make them suffer? So where are we on this? What signal does it send that the U.S. Supreme Court said we're not getting involved, or does it send none, and the next case could go to the court again?
Well, I think what it tells you is that the Supreme Court is not going to lightly intervene, that to justify an intrusion into the process. And remember, I mean, we're at a point in the sort of the jurisprudence of the death penalty where many, many years have developed, many, many avenues of appeal, so much so that, the average stay on death row is 11 years or more. So I think the court's view is that, there's been a lot of judicial work to kind of come up with a process that, like the death penalty or not, is certainly much more fair than in times past. So their interventions should be very limited and very, very selective. Here, you simply don't have evidence that there is and remember, the cruel and unusual punishment is the standard. There is inevitably pain in execution, and executing killers is constitutional if the appropriate safeguards are done. So the question is, at what point do you find that there's something that is sufficiently cruel that has been demonstrated to justify an intervention by the Supreme Court that I think they want to be more selective about? And here it's just really uncertainty as to what the composition is or how it's prepared. And I think their view is that's not good enough. If you're going to get us to go into a process after many appeals have been exhausted, after certainly years have passed since the event occurred, you have to demonstrate compellingly that this is something that's sufficiently cruel to take it out of the ordinary bounds of what's tolerated in what is inevitably a lethal process. So I think that they're being selective, and they're less enthusiastic or they're not going to respond easily to creative arguments.
All right, very interesting. Kendall, always great to talk to you, sir. Enjoy the scenery and enjoy your time, and we'll speak to you next week, sir.
See you next time. Thanks a lot.
All right, great to talk to you. Kendall Coffey, ladies and gentlemen, famed attorney and the author of the book by the same name. You know, it's funny. I was just watching, I forget it, I think it was something on the, old videotapes that I have, like, you know, in the attic. The Elian Gonzalez, I stuck in a tape, and it was the Elian Gonzalez fiasco where they, you know, were taking away, and I remember seeing Kendall Coffey, who had a big part in that whole case, speaking. All right, folks, we're coming back with Gimme 5 on the Steve Malzberg Show on Newsmax Television.
We don't just talk about the news, we talk to those making news. This is the Steve Malzberg Show.